before litigation. After litigation, the plaintiffs invoked appraisal. The appraisal award has been issued. It has been paid. The case that we are relying on, this is not your typical Barbara Technologies where they're entitled to additional damages post-appraisal because Allstate's original payment was reasonable. Basically, the appraisal award and Allstate's original assessment of the claim were pretty much in sync, well more so than plaintiff's position. No response has been filed to this motion for summary judgment. It was filed back in January. It was originally set in February. I think it was reset to April. Then with the COVID, it was reset till now. And despite all this time that's passed, there hasn't been a response filed. And so we're asking the court to grant our motion for summary judgment.
Mr. Gonzalez?
Good morning, Judge.
Good morning.
So Joe Gonzalez on behalf of the Nunez. Judge, so their assessment of what reasonable entails is a point of disagreement for us. There are a couple of issues that have come up with this case that I need I will, after my response, make an oral motion for leave. But briefly, you should know that the case that she's referring to, I believe, does apply here in terms of we disagree that it was not a reasonable assessment put forth by Allstate. My clients then had to expend resources and attorney fees on going through the appraisal process. And so therefore, we believe that the summary judgment here is improper. And although we have not filed a response, Ms. Sandoval and I have engaged in preliminary settlement talks. I can tell you that historically, my office has reached a settlement agreement with Allstate on the majority, if not all, of these cases. And so that being the case, this morning we're asking that the court respectfully grant me leave to perfect the response and maybe give us a little bit of time so that Rose and I might be able to work something out in terms of settling the all claims in this matter.
Briefly, Ms. Sandoval.
Yes, Your Honor. I mean, the problem here is this case has been pending since 2017. It's apparently some sort of 2015 storm claim. He's had months to file a response. You're supposed to file it 7 days ahead of time. I mean, coming here on the day of the hearing and asking for more time after all of this time and going through, the delay associated with the COVID, we object to that. Certainly, I mean, I'm always interested in resolving these claims, and we have, in fact, tried to do that. But again, waiting till the moment of the hearing to, decide, oh, well, now let's try and see what we could do. Again, we object to that. I have made Mr. Gonzalez a settlement offer, but, it seems like settlement negotiations are going nowhere. So.
Okay, let me take this matter under advisement. And on this one, just submit your orders. And I'll probably give it about 2 weeks to make a ruling. So hopefully between now and then you can probably settle it or something. So try settling, okay? Give it a big push. Okay?
Yes, sir, Judge.
Yes,
I'll take a 15-day deal and I'll rule in 15 days.
Okay.
Thank you, Judge.
All right, thank you so much. Anything else, Ms. Sandoval?
No, that's it for me today. May I be excused?
All right, you may be excused. Have a great day.
Thank you. You too.
Mr.
Thank you,
Gonzalez,
Judge.
you may be excused. Yes, sir. Thank you.
Right.
Have a good
Thank
day.
you, sir.
Thank you. Now we're here. Which one? What is? Right here. Okay. Actually, it's 3, right? Miss Garcia. That's Miss Garcia there, and Mr. Laredo. Can you hear me, Mr. Laredo? Well, Miss Garcia, can you hear me?
I can hear you, Judge.
All right. Good morning. There you are.
Morning.
And Mr. Laredo, I'm trying to.
We also should have Mr. Rafael Garcia also.
Rafael Garcia, okay.
And I don't know where he is.
Yeah, yes, he's in the waiting room. We're going to bring him in right now.
You're so efficient. You put us in a waiting room when I'm in court and other places. We're all there together and
Yeah.
waiting.
There's Mr. Rafael Garcia. Can you hear me, sir?
Yes, sir. Can you hear me?
All right. Now, Mr. Laredo, there you are, man. I can see you now. Can you hear me now? Need to unmute, Mr. Laredo.
Yeah,
All
I
right,
can hear you
there-
now, sir.
All
Good.
right, there we go.
Sorry,
Actually,
Judge.
no problem. Actually, we're here on three matters, I believe, but the same case, CL 1964-64D, Martin Munoz versus Villa de Cortez et al.
That's correct, Your Honor.
All right, and what do we have here? Motion.
Your
Yeah.
Honor, I don't know who you want to start.
Okay, we have a motion for leave of to file a third party.
Okay, that would be mine, Your Honor.
Yes, sir.
Rafael Garcia Jr., representing defendants Siesta Village, Inc., doing
Okay.
business as.
Why don't you get closer to the microphone so I can hear more, Mr. Clearly? I think you're kind of far away here.
Rafael Garcia Jr., representing defendant Siesta Village, Inc., DBA Villa de Cortez. We actually filed two motions together.
Uh-huh.
A motion for leave to file third-party action, and also we filed a motion for leave to designate responsible third party.
Uh-huh.
I will tell you that because subsequent to the filing of my motions, the plaintiff has filed a direct action against that party's San Juanita Rodriguez, DBA Jose's Cafecito Courtyard. We will waive our motion. We will pass on our motion for leave to file third-party action. But I still want to assert my motion for leave to designate responsible third party.
Okay.
So I want to proceed with that motion. I mean, the bottom line, this is a slip and fall personal injury case at the Villa de Cortez premises. The plaintiff was dining at a first floor restaurant called Jose Cafecito's Restaurant. They are a party to this case, represented by the Honorable Cindy Garcia. The plaintiff filed suit December 4, 2019. We are outside of 60 days before trial, and so the rules permit me to file an RTP, a motion for leave to designate a responsible third party. And the rule says under 33004F, a court shall grant leave to designate the named party as a responsible third party unless another party files an objection to the motion on or before 15 days after the motion is served. And I don't believe there was an objection. So I would just ask that my motion for leave to designate responsible third party be granted.
Okay, any response? Mr. Laredo?
No, Your Honor, I did file a petition, an amended petition, including that third party to the lawsuit after talking to counsel. I figured out that they might be a responsible party as well. So that's why I filed yesterday.
All right.
Your Honor, we
Anything?
would join in that motion, Your Honor.
Okay. It'll be granted?
Thank you, Your Honor.
Okay, make sure you submit an order for the signature, okay, sir?
Yes, Your Honor.
Okay.
Secondly, I believe the next thing that would be appropriate to be addressed would be the plaintiff's motion for leave to file, motion for leave.
The motion for
Yes.
leave.
Yes, Judge, it's my motion to leave to file late affidavits on this case.
Oh, the late affidavits. Okay.
Yes, Your
Talking
Honor.
about medical affidavits?
Yes, Your Honor. As of September 1st, 2019, the rules say that after filing an answer by the defendants, we have 90 days to file our affidavits. The problem that occurred for me was we had this whole COVID situation come in, and it delayed me getting my affidavits back from the medical providers in the hospitals. Once I did receive them, I immediately filed them. I gave a notice to defense counsel and let them know what was happening. I understand their position of objecting, but I'm asking this court to allow me to file them late based on what's been happening with this pandemic, and it was out of my hands to control.
Yes, sir, Mr. Garcia.
Yes, we filed an objection to the late filed affidavits and objection to the motion for leave. We also filed a motion to compel, which I think does not need to be addressed, but we also filed a motion for extension of time to file counter affidavits. And so this is a new rule. It went into effect September 1st, 2019. The rule says that you must file the affidavits of necessity of services and reasonableness of cost within 90 days. That day would have been June 27, 2020. That day wasn't met. So out of an abundance of caution, we just asserted our objection. But if the court's inclined to grant his motion for leave, we're asking that we have filed alternatively a motion for extension of time to file our counter affidavits, because until the court actually grants leave, we don't know if we have a necessity to bear the expense. And so what we're asking for is an order that would say that from the date the order granting leave is signed, that we be given 30 days from that day to file our counter affidavits.
Okay, granted and granted. Okay.
Your Honor, if I may, I just want the record to reflect Ms. Cindy Garcia also filed, and so I think just for her to get it on the record, she also filed a similar motion, a similar objection and a similar motion as my client.
Okay.
That's correct, Your Honor.
Okay, it'll be granted. Okay, granted.
Thank you, Judge.
And granted for the Garcia team. Okay.
Yes. And I have already submitted an order for that, Your Honor, if the court will look, if the court
submit,
sign.
Okay, we'll get your order done and you submit your order, Mr. Garcia.
Yeah, and to the motion to compel, I think there isn't an issue. We just wanted to make sure when it comes to filing these counter affidavits, it's absolutely necessary that our expert have the diagnostic studies, and so that requires like MRI films and x-rays and whatever else. And so we just wanted to make sure that we had a good medical authorization. So we would just ask that in case the medical authorization that we have is dated, that plaintiff assist us by providing us making sure that we have a good medical authorization so we can collect the diagnostic studies.
Okay.
Yes, Your Honor, I will comply with that. I've already given them one, and I know that sometimes these facilities get a little bit antsy about what we submit to them, and I would be glad to update one or hand them one.
That'll do it.
That's all we have before the report, Your Honor. Thank you very much.
All right, thank you all very much. You all may be excused. Have a great day.
Thank you, Judge.
Thank you. Thank you. Miss Henderson, can you hear me?
Yes, Your Honor.
Yes, ma'am. Which case are you on?
I'm here on CL 140133D. It's Rodriguez versus Guild Mortgage. I'm on behalf of the defendant.
Yes, ma'am. I think they filed a bunch of Rule 11s on this ones. Yeah, there's about 4 things that were set, 1, 2, 3, 4, and I think there's about Rule 11s just about on all of them.
We had a summary judgment hearing and a special appearance set for today, but we passed those because the plaintiff actually passed away. And so his attorney had filed a suggestion of death and plea and abatement. And it's my understanding that is set for hearing still today.
Okay. The plea and abatement?
Yes.
Actually, I don't show that. Let me see here.
I don't have a plea and abatement.
Wait a minute.
There's no plea and abatement.
Yeah, hearing on special appearance, Rule 11. Motion for summary judgment, there's a Rule 11. No evidence, summary judgment, Rule 11, and then the suggestion of death. That's all I have.
No pain, no gain.
Yeah, you may want to call Mr. Shigani, and if there's something going on here, let me know so we can set it up for hearing.
Okay, Your Honor, I'll reach out to plaintiff's counsel and we can get it reset, or
Yeah.
I'll talk to him about it further.
Yeah, just let us know. We'll get you set.
Okay, thank you.
Thank you, ma'am. Have a good day.
You too.
All right, let's see here. We have Mr. De La Garza and Ms. Caso on. Can you folks hear me?
Yes, Your Honor.
All right, good morning, ma'am.
Good morning.
Mr. De La Garza, how about you, sir?
Yes, Judge, I can hear
There
you.
you go. All right, there we go. I have here number 6, 7, and 8. Celia Morales versus Marisela Hinojosa.
Yes, Your Honor.
Okay, let's see here. Here we don't defend much for John. All right, visual protection. And all right, Ms. Caso. Yes, ma'am. What do we have?
Okay, Your Honor. We have 2 of the motions are mine, and it's the motion to challenge plaintiff's objections to written discovery and a motion to compel. When I took the plaintiff's deposition on March 10th of this year, she testified she had been involved in several accidents, but then doesn't really know much more than that. When I asked her how many, she said, I don't know, several. She was able to testify as to one accident that was not her fault, and then briefly about another one where she was not injured and that no lawsuit was filed. After further investigation, after her deposition, something left me, there's a lot more to this than what she testified to. I started looking into her discovery responses, and there was a lot of objections to everything regarding her past history. And then I find out that, in fact, Mr. De La Garza did represent her in a prior automobile accident. And that wasn't, she didn't testify about that accident, and she did, the discovery responses just object. So there's no information other than what I have on the docket sheet that there was this accident that she was involved in. And so I'm asking you, Your Honor, to overrule his objections on written discovery and to fully respond, so that way I know we have all the information and it's all on the table. Through further investigation, I find out that this lady has about 22 claims with insurance companies. So this is something that she's made numerous bodily injury claims and has numerous accidents, and that's perhaps why she can't recall all of those. But I think if she sits down with her attorney, and then they can pinpoint how many accidents she's been involved in and fully disclose everything that we're entitled to know, because at her deposition, we weren't able to get much information. And I have her deposition transcript here. If you would like to go through it, we could go through it, but I tried to ask questions, and then the attorney would object because I was asking questions when she already said, I don't remember. So it wasn't really that fruitful. And so I'm asking you to overrule those objections and have them fully respond and produce the documents requested. And so my motion asks for 3 ROGs and 3 requests for production to be fully responded to.
Mr. De La Garza?
Judge, Ms. Caso wants to do her job for her. I don't, she took the client's deposition. If she couldn't get the answer she from the deposition, that's her fault. The fact that she's gone and investigated all sorts of things, and now she knows exactly how many claims my client's got, that's great impeachment as for her at the time of trial. I don't know what else she can get. If the client doesn't remember, you know, my client's not an eye on something. If she doesn't remember, she's going to say she doesn't remember. So the point of the matter is here is if something was filed, Judge, and it's of record with a local, she has access to it. I'm happy to amend and it, you know, this thing, RFP, request for production number 30. She wants an authorization for income tax returns. I'll agree to that. I'll give her the authorization. That's not a problem. But every other interrogatory and every other request for production that's asking for, there's a total of 3 interrogatories and then 2 requests for production. Those are related to any other accidents that my clients had. She's had a chance to take her deposition. She's asked her these questions. My client doesn't have a filing cabinet full of pleadings and claim documents and so forth. So we responded to this discovery very appropriately. The majority of her requests don't have any limitation on time or scope. So I lodged objections. That's my job to do on behalf of my client. It's not my job to just, throw everything on the table for Ms. Caso to identify. So I disagree with her, Judge. She's taken the depositions. She's performed her own investigation. Anything that she finds, I'm happy to amend any response we've got, pointing to the part of the deposition where my client gave some sort of responsive, answer to any prior accidents that she's had. But short of that, again, her interrogatory requests, Judge, are extremely broad as to time and scope. So I don't know what to tell her. I mean, these are questions that she asked. If she wants to go ahead and ask them again in different ways, you can do that.
You said there's 3 interrogatories and what? 2 requests for production?
3, Your Honor.
It's
And
3 interrogatories. The first one is number 14, number 17, and number 22. And interrogatory number 14, she asks on there, have you ever filed any claim or suit for personal or property damages suffered by you? If so, please state the name as to each claim or lawsuit. And I objected, saying that it was overbroad as to time and scope. I will happily amend that, Judge, to point to any part of the deposition where my client gave a response to that. I have no problem with that.
Okay.
Your Honor,
yes.
they filed a lawsuit in 2017. This is not something that is way out of her realm of memory. She's a 42-year-old woman.
Okay.
I feel like the attorney should assist her, and when responding to that, tell her, well, yes, we represented you in this 2017 lawsuit, and include that date of the accident, because the attorney knows about it. She was involved in that litigation.
Okay.
I think we're wasting the court's time personally, Judge. If Ms. Caso knows about it, then what's the problem? I mean, I don't understand why we're even here.
Okay, number 14, you said you're going to amend. Which is the other one? Which number?
Number 17.
What is
and
that
number
question?
22. 17 asks about any and all previous accidents and subsequent accidents in which you have been involved in, giving the dates and locations of any such accidents. And I can do the same thing on 17. I will amend and I will refer to any portion of the deposition that's responsive, Your Honor.
Your Honor, he's just referring to deposition testimony that was not helpful. She said, I don't recall. And then he would object. So how is that useful? They're abusing the discovery process.
Okay. Okay, then let me hear number 22 again. I mean, that's the last one, right?
Yes.
That was 17. The last one is number 22, Judge, which is the last one. Says, please describe your driving history and record. In your answer, include when you were licensed to drive, license suspensions. I can supplement that one. That's fine, Judge. I will agree to supplement.
Okay, you're going to amend number 14. You're going to amend number 17. You're going to supplement number 22.
Yes.
All right, let's look at, let me look at the request for production. Are there what, similar to the questions?
Yes, it's number 4.
Similar. It's the first one is 4.
Number 4, what is it?
Produce all documents that plaintiff has regarding any disability from any injury or illness prior to the date of the alleged accident. Your Honor, they have this document.
Yeah, any disabilities from prior accident, right? That's what it is.
Yes, Judge. I'll amend that. I'll say none because we don't have any.
Okay, what's the other interrogatory? Which number is it?
Number 13, request for production.
Uh-huh.
It's
what's the
number
question?
13 is the next one. It's a request for production. And that's they're requesting an executed authorization to release confidential information. We've produced all the medical records and bills in this case, Judge. So what else they want?
Your Honor.
I'm sorry. Yes.
since she was involved in other accidents, she may have injured her neck or her back before. And so what they're trying to do is limit us and just give us the records from this accident. But we're trying to develop our defense of pre-existing injury. We're talking about someone who's made many bodily injury claims and has been involved in more than 5 automobile accidents that she testified to in her deposition, but she can't give me details. So at this
Judge.
point, that is why we are needing to get that further information, because she
Okay.
doesn't remember.
So you're saying you want another medical authorization?
She hasn't provided
What-
us with one.
Yes.
We'll give them a 2-year medical authorization, Judge. I mean, limited to 2 years to the same injuries alleged in this case. I mean, more than that is a fishing expedition.
Your Honor, I would request that the authorization go back to 10 years.
I don't know any court that does 10 years.
My God, I don't know.
Maybe
Does
3.
anybody have records for 10 years? I don't think nobody does, but
Yes. I mean, come on.
Your Honor, they do keep the records for as long as they have them. They definitely do have them
Uh-huh.
for more than 10 years.
okay. I never heard of that. I've always heard 5, maybe at most 7,
And
but anyway.
10 years is ridiculous, Judge. It's 2010. I mean, we'll give them, I'll happily give them 2-3 years as related to the injuries. In this case, the same body parts. That's fine. You know, that's relevant.
All right. What do we go 5 years? Let's do 5 years.
That's fine. Judge. 5 years. That's fine.
Okay, but you gotta amend and supplement the other questions. And then after we
I will.
we
We'll
go
do-
through all of that, let's see what else needs to be tailored or
And the last one she's asking for, Judge, is the number 30, and that's a tax document for the last 5 years. I'll give her that. That's fine.
oh, and then the income tax returns also? Was that
Yes,
another one?
yes, Judge.
Okay. Well, what was number
That's
30
the
again?
last one.
What was
Number
number 30
30
again?
is 5 years of income tax returns or a authorization in lieu thereof.
All right, let's do the 5 years. Let's see what we come up with. Let's go with this right now, and then if we need any more tuning up, we'll hear it again.
Your Honor, and I'm asking him to fully disclose the injuries and the records from that prior automobile accident that she filed a lawsuit for 2017. Surely Mr. De La Garza has those records if he filed a lawsuit on her behalf.
I actually don't, Judge, because when I close a file, I just go out, I get rid of the file. I erase it, delete it after we close the file. That's something we sign off on when we settle a case.
I thought you were supposed to keep a file for about 5 years, Mr. De La Garza.
Yeah.
Maybe we are, Judge, I don't know, but I have some language in the disengagement
Contract.
letter when we're done that allows me to go ahead and close everything out.
Oh. Well, I guess to the best of your ability, you better answer that question on what, the 2017 accident you said, or lawsuit, what was it?
Your Honor, and I feel like this is something that he's trying to hide information from us, and it's really discouraging, because that moves us to our next motion, is his motion for protection on the family doctor records. This lady's claiming she doesn't remember. Her attorney's claiming he destroyed all the records. So we need the records from the family care physician going back to at least 10 years, Your Honor, because the person who's going to have these family these records, these MRIs that she testified that she got, but she doesn't know where, I'm sure her family doctor will have them. So I'm asking on that motion for protection that you at least give us up to 10 years for Dr. Yazji.
What's number,
Judge.
what, yes.
It's my motion for protection because they filed this is the next motion. It's my motion, the plaintiffs. I filed a motion for protection. They filed a deposition on written questions to Dr. Yazji. If my client had gonorrhea 8 years ago, Judge, it's my obligation and duty to defend this deposition on written questions. So I have no problem. The reason I filed the motion for protection is because it's an open request for all records of all time of my client. So I'm requesting that be limited in time to 3 years before the date of the accident, Your Honor.
Your Honor, she testified at her deposition that Dr. Yazji has been her primary care physician since 2003. And if Dr. Yazji has those records, I'm asking to go all the way to 2003. And if he doesn't, then he'll produce what he has, the most recent records. But we're dealing with someone who doesn't remember anything. A 42-year-old that also testified at her deposition, she has no memory loss issues. Should get to find out if the MRI, she says she had a prior MRI, but she doesn't know where. We need to see those MRIs. We need to see, are they the same as the MRIs after this
Right.
accident? We're entitled to that information to have our defense.
Wouldn't it be the information dealing with like back injuries, neck injuries, something like
We
that,
can limit it to neck and back, which are
to
the
neck
two
and
injuries
back, and
she's
which is
claiming.
what's in contention right now?
Yes.
Judge, I'll agree to limit it to that as long as it's like you did on the last one, you limit it to 5 years from the accident. 10, 17 years, 2003, that's crazy. I mean, it's 17 years ago.
But this is a lady who's had a lot of automobile accidents and can't
It's
recall.
called fishing, Judge. They're fishing.
But many
I
times,
mean, they're fishing for information to see what they can find.
many times a person might have had 10 years ago a back problem, and then they are all of a sudden asymptomatic, and then now they have an accident and they go back to the back problem.
And that's why we need the records to see that. I mean, the records will reflect that.
But I think you're still responsible because if they were already asymptomatic, they already healed from the accident from 10 years ago. Now you hurt them again. It's like, it's a brand new injury. It's a brand new.
And that's
That's
why
how I
we'll
see it.
see that. I mean, if she was complaining of back injury since 2003 and it's a chronic back condition, it's something that we are entitled to use in our defense.
Okay. On that one, let's go to 10 years on that one, but only to like a back injury, neck injury, things like that. Nothing personal, nothing else.
That's fine. You're
Okay.
all right.
Anything else?
Thank you, Judge. That's it, Judge.
Okay, like I said, let's see where that takes you, Ms. Caso and Mr. De La Garza, where we're gonna end up. And then if we need to come back to tune up, to do some more tuning up, let me know. Have you all mediated this case?
Thank you, Judge.
No? Have you all
No.
No,
mediated?
Judge, we have not.
Okay. All right. I want to let you know that when we do go back to normal, if we ever do, the criminal cases and the family law cases are probably going to have priority. So this case will be like in the back burner with the other civil cases. So we can try to settle it or something, try to come to an agreement. Okay?
Judge,
Just to let you know.
will the court authorize me to file a DCC on this one as well, just like the one from 9 o'clock? Even though
Yeah.
we haven't mediated it, will the court authorize that?
Yeah, follow DCC. Follow DCC. Okay?
Thank you, Judge.
Thank you.
Thank you so much. You all may be excused. Bye-bye.
Thank you. Have a good day.
Have a good day. What else? All right, that'll do it for the 10 o'clock docket. We're coming back when? Later today? All right, we'll come back later today. Thank you so much.